Good evening, this is Laws 19038, Planning and Environment Law. It's week number 6. And tonight we're talking about Chapter 3 in Bates, the prescribed reading. And the reading relates to environmental protection or environment protection and the common law. Before I start, just some brief discussion about the assignment. Now, the assignment is due on the 7th of May. That's at 11:45 p.m. You'll recall that my policy is to ensure that all assignments are submitted on time. If the assignment is late, then you will suffer a deduction of 5% per day for every day of late submission, subject to a cut-off, and it's very likely that the cut-off, although it's not confirmed yet, but the cut-off is likely to be Saturday week after the assignment is due. So Thursday the 7th, that would be Saturday the 16th of May would be the very final day that I would accept submissions, more than likely. I may make that earlier or I may make that later. But the point is that it's very important that you submit on time. When you do submit, you'll need to upload in final form. I won't mark any draft assignments. And if you do need to make an application for an extension, remember, of course, that needs to be supported by good reason, probably supported by some documentary evidence to support the application for the extension. And it's very likely that in most circumstances I would say no. I certainly don't accept any application for an assignment extension after the due date. If you're going to apply, it has to be before the due date, otherwise it won't be considered. All right, sorry to be tough, but it's important that in legal matters that you are ready to go on time when needed to. This is not intended to be an overly difficult assessment piece. The first question, which deals with case law, is designed to test your understanding of how a court would look at a factual scenario and ultimately come to its decision. There's a few things about this which are interesting. The first is that as you're reading the material, I want you to think about how it is that the lawyers, through the evidence which was called, went about trying to prove their case. And you'll see that there are experts who were involved in this case, and those experts don't just appear on the doorstep of the court. Arrangements need to be made for them to be there. So think about what you would do if you were in a situation of advising a potential litigant in court proceedings, and think about what type of expertise you would need to introduce and how you would run your case. In other words, think about the whole story of how that case came to be in existence and ultimately led to the reasons that were proffered by His Honour. Also, when you're reading the case, think about the way in which His Honour structured the judgment. I talked before about the IDAS method, which is where lawyers identify the issues, talk about the issues that need to be determined, and so on. So think about the way in which the court has structured that decision, and also look at the way in which the court has footnoted or referenced the material. So you'll need to do that in a similar way. The second assessment piece is really not so much about environmental law to the same extent, but it's more about planning law, and there is the emphasis on the Sustainable Planning Act in a number of different ways. So ecological sustainability, the IDAS method, and the IDAS process, and outlining the way in which concurrence agencies and referral agencies go about dealing with their tasks. And sorry, mental blank, I mentioned before IDAS, I meant to say IRAC when talking about the way courts write their case, which is issues, rules, application, and conclusion, as opposed to IDAS, which is the planning and scheme system incorporated into the Sustainable Planning Act. Now, on UCRU, you may well have seen some guidelines as to how you might go about answering some of those questions. So question 2.1 4 deals with IDAS, and it's your opportunity to talk about IDAS generally, describe IDAS, what does it mean, talk about how it came into existence, what led to it, what were the problems, what were the issues that confronted lawmakers before the IDAS system was implemented, talk about when it was first introduced, give some statement about the process, talk about how it works in practice if you can. Provide some commentaries about the agencies that might be affected by the IDAS system and how is it controlled, how is it implemented, how is it enforced, and what's it intended to achieve. Now that requires some commentary about what it was the situation before IDAS so that you can logically see what it means once it's implemented. Talk about the political discussions that took place before it was introduced and how the guidelines, the policy guidelines, ultimately were reflected in that legislation, and give some statement about how effective it is in dealing with development applications and other aspects of development. Now, it may be that you speak to industry experts, that you gauge some real life experience about talking about these issues outside the realm of pure academic thought. So, what are some criticism of the IDAS system? Has it achieved what it meant to achieve? And talk about some ongoing discussions of its continued practice. Should it continue? Is it a good idea? Does it need to be changed? Things of that nature. And then think about, well, what is IDAS? Does the Sustainable Planning Act include all the rules and the regulations which pertain to it? So they're just some general guidelines. Now, I don't propose to give you that same sort of detail in relation to all of the questions, but that was just something to kickstart you in case you're having some trouble in getting started. Likewise, question 2.5 deals with the matter of impact assessable development, the criteria, the standards and the documentation against which impact assessable development applications are appraised. So you'll need there to talk about the difference between the assessable and the non-assessable applications, talk about how and when applications are categorized, talk about when they're code or impact assessable, or perhaps both. Explain the procedure and the steps that are relevant when an assessment development application is considered. Talk about the role of the assessment manager. What does the assessment manager have to do? What are the tasks associated with that role? And how does the assessment manager go about considering the merits of a particular assessable development application? Talk about concurrence agencies, how they are introduced into the practice, into the role, and what is their power. So talk about the processes that are involved. You may have to talk to industry experts to get some more insight in this. Talk about how submitters or third parties can become involved in the process. Talk about the possible outcomes associated with the appraisal of an impact assessable development application, and then talk about the recourse available to parties following an assessment. And that then neatly would lead us back to the Predajon situation, where of course we have the litigation that follows the decision which was adverse to the interests of the prospective developer. All right, so that's just to give you some idea, to give you some motivation to get started on that assessment. Please don't be late. It's not meant to be an overly difficult task. It's not a long assessment piece. It really is an opportunity for you to provide some genuine input from your own reading and your own experiences, and also your own research and observations. Okay, now this week the prescribed reading was Chapter 3 of Bates, which deals with the issue of environment protection and the common law. So I've provided you with my formal summary or formal overview of that chapter. I just want to talk in more general terms about this concept of common law rights as they pertain to property. So obviously, in undertaking that discussion, we need to understand what we mean by common law, and then we have to understand what we mean by the rights of a property owner or a person who has an interest in property. And there is a difference. So let's talk about common law firstly. So common law is essentially the law which is created through court decisions as opposed to statutory law through legislation. And at common law, there are a number of different actions which are available to potential litigants which touch upon the question of property and property rights. So, for example, there might be negligence or nuisance, which are issues that might affect property owners or people that live adjacent to property owners. And we call that branch of law, that's part of the tortious law, torts, which deals with issues of negligence and nuisance in particular. So at common law, property owners had certain rights. And the common law, which is through the courts, saw it as their role to essentially uphold the rights of landowners in terms of the ability to use their property as they see fit. And in week one, we talked about the inherent conflict between the interests of the public generally, both present and future members of the public, to have the environment protected, compared to what was perceived to be the common law right of a property owner to use his or her land in whatever way he or she saw fit. The only real limitation on that was that neighbours or people affected by what happened on the property would be able to sue in torts for damages suffered as a result of those foreseeable actions of the property owner. So, for example, if a property owner owned a property and, irrespective of any issue of planning control or amenity of the area generally, decided to run some sort of noxious industry, right in the middle of residential areas, and I'm talking as if we didn't have legislation. At common law, the courts would say, it's your property, you can do whatever you like. But what would stop them is the fact that neighbours who suffered some sort of injury or damage or loss would be able to sue in torts, which is also in common law, or through equity in common law, in obtaining some recourse. So the legislation was introduced essentially, if you like, to mirror the policy of the government, which was to protect the environment for the benefit of all. So that's what we mean by common law rights, common law remedies, etc. The other concept is property ownership or an interest in property. And if we think back to earlier talks, we talked about Indigenous, the way in which Indigenous Australians dealt with the issue of property. It was more a communal aspect. Nobody owned the property, but everyone had the right to use the property. So in a sense, if you like, the way in which it was determined was like a licensing situation, that you have the right to be there, but you don't own it. And that's very much at the opposite spectrum of what was introduced through white occupation, if I can use that term, where common law rights were sacrosanct and people owned that land. They owned not only the land on the surface, but they also owned the resources below, minerals, petroleum, etc., and also had the rights of ownership and control of the airspace above. So that's at pure common law. And in between, we have the situation as it is now, where people, sure, own the land in what we call fee simple, but it doesn't mean that they own or have a reservation of the minerals and petroleum below. Those things are reserved to the Crown. We talked about the Crown as being like the household. So the Crown has the right reserved to it in relation to resources below your land, so you don't own that. And through case law and legislation, people no longer have absolute rights to control the airspace above. So it is limited in that sense, and it's also limited by planning controls and environment law in terms of what you can actually do on that land that you happen to own. So that's, if you like, the concept of property ownership. There is the other thing, and that is property interest, having an interest in property. And that can be a proprietary interest or it can be a permissive interest. So a proprietary interest is, for example, someone that has an interest by way of lease or an easement. It's a formal legal arrangement where they have an interest in the property, even though they don't own it. Contrast that to people that have a permissive interest in land, which is generally a license to use that land, but you don't have a proprietary interest in it. So when we talk about common law rights versus environment protection, we need to bear in mind that when we talk about the common law, it's not necessarily just one thing. And when we talk about property, that's not necessarily just one thing or one concept. So the best type of ownership, or I suppose the most extensive type of ownership available in our system, is that which we call fee simple. And fee simple, for all intents and purposes, means that you own the land, subject to those reservations about minerals and petroleums, which are in the deed of grant of land. And you can do with it what you like, subject to planning and environment legislation and common law issues. And if you don't have an interest in the ownership, then you may have a license. So when it comes to the issue of compensation, there is always going to be the potential for an argument as to whether the person who seeks compensation actually has a proprietary interest in land, which is sufficient to support a claim for compensation, or whether they simply have a permissive license, which may or may not be assignable, for example, to another party. All right. So I mentioned that courts have always protected the rights of property owners. They do so really in two ways. The first is by authorising the owner of the property to do what they wish, subject to the issue of common law claims by neighbours, and more lately through statutory intervention. But also they do it through guarding against the excess of bureaucratic power. So when we think about our separation of powers, we have Parliament, which makes the law, we have the courts that administer, and in the middle we have the executive, which deals with the administration issues. Now, in the course of exercising bureaucratic power, the executive, that is the administrators, may make certain decisions, may do certain things which affect landowners. The courts have typically come to champion the cause of landowners to ensure there is, or guard against, the excess of bureaucratic power in those circumstances. So there's another way that the courts will come to the aid of property owners. Now, the situation is, of course, that we are now subject to environmental legislation, and it's a good thing that we are, so that there are protections in place for the benefit of society as a whole, both present and future members of society. But sometimes people do things which are permitted by way of license, so they have an authority to do something. The question is, how far can they use that as an excuse or a defence in circumstances where damage is nevertheless caused? So here's where we may have the common law rights for a neighbour to sue for example, negligence or nuisance as a result of what someone has done, only to be confronted by the owner of the property saying, my defence is that I had the authority under statute to do what I'm doing, so even though you suffered loss, I'm sorry, you can't claim against me. We're going to see this a lot more in terms of the role of councils and in relation to the matter of climate change. So it may be that through climate change, circumstances will change dramatically. People will suffer loss. They'll want to make claim against others for that loss. If someone has done something which was authorised by statute through the executive, then the question is, where will these claims for loss fall? Will it be the owner of the property? Will it be the authority that made the decision or perhaps even undertook the work themselves, or will it be carried across the society generally through, for example, statutory schemes or compulsory insurance? These are things that need to be considered down the track by parliaments, and it's worthwhile considering that as you undertake your reading. Finally, on that chapter, I just want to talk, well, on that area, I just want to talk about the way in which industry in particular can use litigation to dissuade or stop environmentalists or protesters, and that is through what we call SLAP actions. SLAP is an acronym meaning strategic litigation against public participation. And the idea of a SLAP action is to essentially tie up defendants in litigation that is both protracted and costly, and carries with it the risk of a costs order, so an attack on people's financial resources. So if you haven't had a chance to view the excellent video which I conducted with Roger Curry, it's very much worth reading, because in that Roger talks about his environmental association and the role that it played in laying claim against government action, and it's a very interesting video. And he talks about these SLAP actions and the way in which defendants can be caught up in this costly and lengthy litigation. Okay, so I'll leave you to read chapter 3 in terms of common law and common law principles, but I will just close by talking briefly about statutory schemes and innovations. This is going to become more and more important down the track. So firstly, as I mentioned earlier, landowners are subject to the fact that natural resources, minerals and petroleum, are reserved and remain in favour of the Crown. And that occurs by looking at the deed of grant. So when you own your property as fee simple, you will see that it is subject to reservations on the deed of grant. So the Crown has the ability to use these natural resources. And the Crown, through its executive, will somehow try to control the use of those resources. And we're not talking just petroleum and minerals which are subterranean. We're also talking about resources that might flow through properties, such as water. So water allocations are granted and controlled by the Crown, and that's a huge area of administrative task-making. So statutory schemes, if you like, provide an opportunity for the administration of and rationing of these resources for individuals, and also for individuals in different ways that they wish to use the resource. There have been of late ways in which the concepts of property rights have been married in with environmental issues. So, for example, in relation to irrigation, schemes involving water trading have been established. And it's a way of trying to balance the various interests of protecting the resource versus allowing people to use their property. Sometimes these schemes carry with them an entitlement to compensation. And that entitlement to compensation will often be linked or referenced to the legal status of the entitlement. So, for example, before we talked about someone that has a license. Generally speaking, when it comes to compensation, the person who has a mere license, which may or may not be transferable, will not necessarily be entitled to any form of compensation. That is likely to be different if the person is able to claim a proprietary interest. One of the problems with statutory schemes, and now I'm thinking for the moment of fishing and fisheries allocations, is that there is always the risk that the process can be corrupted through cheating. In relation to fishing, for example, there might be the use of black marketing supplies which get round quotas, or perhaps even processing at sea, which will colour the situation. So it's all very well to have these processes in place and to make these administrative and executive arrangements, but sometimes enforcing those and monitoring in a real sense is a much more difficult thing. Finally, can I say that the way in which these policies, these schemes are created and implemented often comes about as a result of the policies adopted by the government of the day. And those policies which are adopted by government are often very heavily influenced by public sentiment. So public sentiment has a role, for example, in providing the government with some idea of what is perceived to be the appropriate rationing, or the best way of rationing these natural resources and applying compensation. So if, for example, there is an issue regarding the compensation of farmers, then public policy would dictate that any restriction on the right of a farmer to use their property in a certain way should be compensated, because otherwise the farmers are, delivering benefits for the community as a whole. Okay, unless there are any questions, I'll just move on to talk briefly about next week. So week 7 next week, prescribed reading chapters 8 and 10 of Bates. And I do encourage people to contribute through UCrew. I've tried to kickstart some discussions in relation to the assignment, but feel free to add to that, contribute, have a look at what's there, maybe add your own thoughts as well. All right, well, thank you very much for listening, and I'll end this recording now.